24 hours, that's all it took. No courtroom, no lawyer, no appeal. Italy put an imam on a plane, and by the time most people finished reading the headline, he was already gone. But here's what the coverage missed. He didn't go quietly. He called his answer scientific. His own mosque walked away from him. In the country he came from, it turned out his preaching was illegal there too. When the footage aired, Italy didn't debate. It moved. Some lines it had decided don't get argued over. What he actually said and why a single hidden camera ended it all in under a day, that's the part this story is really about. The footage didn't come from a tip-off. It came from a hidden camera. In early April 2025, an investigative reporter named Francesco Leone walked into a mosque in Brescia, a mid-sized industrial city in northern Italy, not as a journalist, but as someone asking questions. He was working for Fuori dal Coro, one of Italy's most watched investigative programs on Rete 4, the kind of program that doesn't publish press releases. It just rolls tape. What Leone recorded that day wasn't a sermon. It wasn't a heated debate. It was a calm, methodical conversation with a 25-year-old imam named Ali Kashif, a Pakistani national who had been living in Italy for 6 years. Leone asked him directly about the minimum age for marriage in Islam. Kashif didn't hesitate. He said 9 years old was acceptable. Scientifically acceptable. He used that word scientific, not as a slip, not as a figure of speech. He framed it as a legitimate doctrinal position with biological grounding. Think about what 9 years old actually looks like. A 9-year-old is in 4th grade. She's learning multiplication tables. She still measures time in summers and school breaks. She does not yet have a legal identity independent of her parents in any country in the developed world. That is the child Ali Kashif, described as eligible for marriage. And he said it the way someone explains a math problem. No agitation, no lowered voice, just a straightforward answer to a straightforward question. That's what made the footage so difficult to watch when it aired. It wasn't the content of a fringe radical screaming into a microphone. It was the composure of a man who genuinely believed he was teaching something normal, something he felt confident enough to say on camera, in a building where he held religious authority, to a stranger who had just walked in off the street. Ali Kashif had been operating in Brescia for 6 years. 6 years of community access, 6 years of pastoral influence over congregation, 6 years during which this framing marriage to a child justified, as science was apparently available as a lesson for anyone who asked. That's the part that didn't make it into most coverage. Not just what he said, but how long he had been saying it, and to whom. Social danger. 2 words. That's the legal classification Paolo Sartori reached for, and if you've never heard of it, that's exactly the point. Sartori is the questor of Brescia, the senior police commissioner with direct executive authority over public order in the province. His office reviewed the Fuori dal Coro footage within days of it airing, and the question he faced wasn't whether what Kashif said was offensive. That wasn't a legal standard. The question was whether it crossed a specific threshold written into Italian law. It had. Sartori invoked Article 4, Paragraph 3 of Italy's consolidated law on immigration, the Testo Unico sull'immigrazione. Most Italians have never read it. Most lawyers outside the immigration field couldn't quote it from memory. But inside the Italian security apparatus, it is one of the most precise instruments the state possesses. Here is what that provision actually does. It allows the state to expel any foreign national whose continued presence is deemed incompatible with public order or national security. Not convicted, not charged, not even formally accused of a crime. Simply deemed incompatible. Think of it like a circuit breaker. In a normal criminal case, the system runs on a long circuit investigation, charges, hearings, defense counsel, appeals, counter-appeals, months, sometimes years. Article 4, Paragraph 3 cuts that entire circuit short. The moment the questor signs the classification of social danger, the long circuit goes dead. What replaces it is a direct administrative line from the commissioner's desk to the departure gate. No trial, no defense window, no injunction from a civil court to delay proceedings. The label itself, pericolosità sociale, social danger, carries a legal weight that most people don't realize exists outside of wartime emergency law. But it does exist, and it was designed precisely for situations where waiting for a criminal conviction would make the state's response arrive too late to matter. That's the architecture Sartori used. He didn't need a judge to agree. He didn't need a prosecutor to file charges. He held the authority in his own office under a provision that had been sitting inside Italian immigration law for years, largely invisible, rarely discussed in public, but entirely operational. When the footage from that mosque in Brescia confirmed what Kashif had said on camera calmly, without any apparent awareness that he was being recorded, the classification process began almost immediately. Social danger, filed, signed, executed. And once that label was attached, Ali Kashif had no legal ground left to stand on in Italy. Here's what most coverage left out entirely. The broadcast didn't create Kashif's legal problem. It revealed one that had already been building inside the system quietly, automatically, without any public announcement. Ali Kashif's Italian residence permit had not been renewed. The Ministry of Interior's automated screening process had flagged his file and denied the extension some time before the Fuori dal Coro footage ever aired. He was, in the technical language of Italian immigration law, already living in the country on expired status, not because of anything the cameras captured, because the state had already decided, through its own routine process, that his continued presence did not meet the threshold for renewal. That's the part that changes the entire picture. When people watch the deportation unfold in under 24 hours, the natural assumption was that Italy had reacted to the broadcast that public outrage had forced a rushed decision by an embarrassed government. That framing is understandable. It's also wrong. What the footage actually did was detonate a trap that was already set. Think of it like a locked door that had been waiting for someone to turn the handle. The hidden camera footage was the handle. The lock had been placed months earlier by a ministry database that processes tens of thousands of residency files and flags those that no longer qualify. Kashif's file was already flagged. What Sartori's office needed was documented evidence of active threat, and the broadcast provided exactly that in real time on national television. Once the social danger classification was applied and the deportation order signed, the operational sequence moved without interruption. Kashif was taken into administrative detention. No press conference, no opposition statement, no injunction from a sympathetic civil court. The machinery had been engaged, and there was nothing left to pull it back. From the detention facility in Brescia, he was transported approximately 90 kilometers west to Milan's Malpensa International Airport, one of Italy's two major international hubs, and the standard transit point for high-priority deportation cases requiring direct intercontinental routing. The flight went to Islamabad. By the time Italian morning news programs were summarizing the story for their audiences, Ali Kashif was already out of European airspace. That's 24 hours, start to finish. And not because Italy panicked, because the groundwork had already been laid and the broadcast simply made waiting any longer impossible. Now here's the part that dismantled every framing the story was given online. The moment the footage aired, certain voices began building a familiar narrative. That this was Europe versus Islam, that Italy had acted against a religious minority, that the deportation was a cultural attack dressed up as a legal procedure. That framing didn't survive contact with the facts. Not the Italian facts, the Pakistani ones. Ali Kashif was a Pakistani national. He was born in a country with its own legal system, its own courts, its own religious jurisprudence. So the question worth asking was straightforward. Well, what does Pakistan's own law say about what he preached in that mosque in Brescia? The answer is unambiguous. On May 30th, 2025, Pakistan's Child Marriage Restraint Act came into force across the Islamabad capital territory. The legislation was signed by President Asif Ali Zardari. It had been championed through parliament by legislator Sharmila Faruqi. The law sets a hard minimum age of 18 for marriage for both men and women and backs that threshold with criminal penalties ranging from 1 to 7 years in prison for violations. 18, not 9. But the legal picture goes deeper than statute law, because in 2022, Pakistan's Federal Shariat Court, the highest Islamic jurisprudence authority in the country, issued a landmark ruling on exactly this question. The court found that banning child marriage is fully compatible with Islamic teaching, not in tension with it, not a compromise position, fully compatible. The court's position was clear. There is nothing in Islamic doctrine that requires or compels marriage at the age of 9. The prohibition, the court ruled, stands on solid religious ground. So what Ali Kashif described as science, as legitimate doctrinal interpretation, was not only illegal under Italian law, it was illegal under the law of the country he came from. And it had been declared incompatible with Islamic jurisprudence by Islamic judges sitting in an Islamic court. He wasn't defending a tradition. He was an outlier rejected by both sides of the argument. That rejection was immediate and public from within Brescia itself. The Minhaj ul Quran Association and the Al-Noor Islamic Center, two of the most established Muslim organizations in the city, issued written statements within days of the broadcast. They were unambiguous. They did not soften the language. They distanced themselves from Kashif personally, rejected his views as unrepresentative of their communities, and made clear that what he had said on camera did not reflect Islam as they practiced or taught it. Not Italy, not European secular law, his own mosque community, his own country's courts, his own religion's highest judicial authority. On all three fronts, Ali Kashif stood completely alone. Now pay attention to what didn't happen. No legal challenge from a civil liberties organization, no emergency injunction from a human rights group, no statement from international bodies demanding due process review. No parliamentary opposition figure in Italy, not from the left, not from the center, stood up to argue that a man who had publicly endorsed marriage to a 9-year-old deserved more time on Italian soil. The silence was total. And that silence is the part of this story that most coverage treated as background noise. It wasn't. It was the most revealing thing about the entire event. Giorgia Meloni's government said what you'd expect. The deportation was fast, appropriate, and a demonstration of the state's commitment to protecting Italian values and Italian children. That position was entirely predictable from a right-wing government that had built much of its political identity around firm immigration enforcement. But the opposition said almost nothing. And that is the number that actually matters here. Not the 24 hours, not the 90 kilometers to Malpensa. The silence from the side of Italian politics that would normally reflexively push back against an administrative deportation that bypassed a courtroom. They didn't push back, because they couldn't. There is a concept in legal philosophy, sometimes described as biological self-defense. The idea is that certain protections, the physical safety of children being the clearest example, sit at a layer of social consensus so foundational that standard procedural rights arguments cannot reach them. They are not negotiable through courtroom debate. They are not subject to the usual political calculus of who benefits from which position. When that layer is breached, the normal machinery of rights-based litigation simply doesn't activate. Not because it's been suspended, because no one in a functioning civil society is willing to be the one who activates it in this context. Italy's National Commission on Children's Rights had noted in its 2025 annual report that documented cases of underage marriage advocacy within immigrant communities were among the most difficult to prosecute through standard criminal channels, precisely because the advocacy happens in closed spaces, in private, away from the reach of ordinary law enforcement. What the Fuori del Coro footage did was remove that shield entirely. It put the advocacy on a national broadcast, in daylight, on record. The result wasn't just public outrage, it was the collapse of every political argument that would have otherwise been available to anyone defending the process. To challenge the deportation was to be seen defending the substance. No party, no organization, no civil society, body in Italy was willing to accept that position. That's not a political failure. That's a political system recognizing, in real time, exactly where its own floor is. Italy was not operating in isolation. The same month the Brescia footage aired, legal teams across Europe were watching the outcome with close attention. Not because the case was unusual in its facts, religious figures making extremist statements about children is not a new problem on the continent, but because Italy's response time was. 24 hours from footage to departure gate is a number that other justice ministries notice. The United Kingdom had reached the same destination through a different route. In January 2026, Northampton Crown Court handed down a criminal conviction against Ashraf Osmani, a 52-year-old cleric found guilty of conducting a nikah ceremony, an Islamic marriage for a minor, in direct violation of the country's minimum age legislation. The case took months to prosecute. It required police investigation, charging decisions, a full criminal trial, and sentencing. The outcome was the same as Italy's removal from any position of religious authority. Permanent reputational damage, criminal record, but the timeline was measured in quarters, not hours. That contrast is what makes Italy's administrative model interesting to the rest of Europe right now. France, Germany, and the Netherlands are each dealing with versions of the same structural problem. Their courts are backlogged. Their human rights litigation pipelines are congested. Cases involving religious advocacy of harm to minors can sit in the system for years, before resolution years, during which the individual in question continues to operate, continues to preach, continues to have community access. Italy's Article 4, Paragraph 3 mechanism bypasses that entire congestion. It doesn't wait for the criminal justice calendar. It doesn't require a prosecution team to build a case file over months. It requires one thing: a documented, credible demonstration that the individual's presence constitutes a social danger. When that threshold is met, the administrative route closes in hours, not years. What European justice ministries are studying now is not whether Italy was right. That question has already been answered by the cross-party silence we discussed. What they're studying is whether their own domestic immigration frameworks contain equivalent provisions, or whether those provisions need to be written in. This is how legal innovation moves across borders, not through international treaties or coordinated policy announcements, through one country acting and others watching the clock. Brescia, 24 hours, Malpensa, Islamabad. That sequence is now a reference point, a template. And the countries that have been struggling for years with the slower machinery of criminal prosecution are taking careful notes. So what was Italy's decisive blow? It wasn't a courtroom verdict. It wasn't a lengthy criminal sentence. It was the complete removal of operating space, the administrative elimination of any platform from which an extremist could continue to preach, recruit, or claim the protection of religious tradition as cover. 24 hours. That was the window from footage to flight. And the outcome wasn't contested, not by the Italian left, not by Islamic jurisprudence, not by Pakistan's own law. Every potential shield had already been stripped away before the deportation order was even signed. What remained was a single administrative decision, executed with a precision that no criminal trial could have matched. This is what the Brescia case actually established. When child protection law collides with a distorted interpretation of religious doctrine, Secular law wins, not by force, not by hostility toward faith, but by consensus, including the consensus of progressive Islamic legal scholars and Muslim-majority governments who have spent years building their own legislative frameworks to protect children from exactly this kind of harm. The Imam landed in Islamabad, a city governed by laws that forbid what he preached, a country whose highest Islamic court has already ruled that those laws are fully compatible with the religion he claimed to represent. He had no legal ground left, not in Italy, not in Pakistan, not in Islamic jurisprudence. That's the answer to the question this story started with. But it opens a harder one. The 24-hour administrative deportation model is fast, clean, and in this case, difficult to argue against. But the same mechanism that removed Ali Kashif from Italian soil operates without a courtroom, without a judge, without any adversarial review of the evidence. It works perfectly when the target is clearly what this man was. The question is, what happens when it isn't? Is 24-hour administrative removal the right tool for protecting children from genuine extremism? Or does it set a precedent that a future government could use to remove people for reasons that aren't nearly as clear-cut? That's the debate that isn't happening in public yet. But it should be. Leave your position in the comments below, because this question doesn't have an easy answer, and it deserves more than a headline.